I'm going to be calling this meeting to order. We do have a quorum. What I'd like to do first is to have everybody go around and introduce themselves. We do have some guests here, other people who are very interested in what we're going to be discussing today, and I want to just right now say I appreciate them being here and taking the time. I'm Steve Knox, I chair the committee from Albany.
Mark McConkey, Carroll County Delegation Chairman and Chairman of Public Works and Highways.
Peter Pohl, retired forester.
Sandra Brocar, farmer.
My name is Ken Robichaud. I'm the Carroll County Administrator.
Amanda Bevard, Chairman of the Carroll County Commissioners, as well as a Carroll County farmer.
I'm Susan Gaudet from Wakefield, Recording Secretary.
I'm Tom Howe. I work at the Society for the Protection of New Hampshire Forests.
Again, I want to thank all of you for being here today. This is going to be an interesting meeting. Over the past 7 or 8 months, assisted listening sessions, one of the topics that we have discussed a little bit is putting some, if not all, of that almost 900 acres of county land under conservation easement. And several months back, Tom Howe came up and gave us 2 hours of an overview of what that meant. At the last couple of meetings, the committee has felt that we're at a point where we really want to take a good hard look at that and decide if this is the right avenue for us to go. And we appreciate very much Tom coming up, taking time out of a very busy schedule this summer to give us that information. And what I'd like to do in starting off is basically, again, Tom's gone over this before, but again, just give us a brief overview of putting the land under conservation easement. Just really what does that mean? What are some of the limitations? What are some of the constraints and so forth that we want to take a look at? And maybe how important language is and what needs to be included in that conservation easement. And just what might be one to be the next steps in going forward with that. So Tom, I'm going to turn the meeting over to you. As we go along, I hope we can add, if we have questions, we bring those up now rather than waiting till the end when, if there's anybody like me, they'll forget them.
Absolutely.
Okay, the floor is yours. Go, Tom.
Well, thank you. What I'll do is just give you kind of a brief review of some of the points that I made previously at my first meeting with you all, just in terms of explaining what a conservation easement is and how it works, just perhaps as a refresher, if nothing else. And then we can, get into more of the nuances or questions or specific things that are going to be helpful for you to talk more about, that hopefully I can help you explore further based on your considerations and thinkings. So to back up for a moment, a conservation easement at its core is a written promise by the landowner that the land will never be developed further into the future. And that written promise takes the legal form of what is typically called a conservation easement deed, document that gets recorded at the Registry of Deeds and becomes a permanent part of the title, if you will, or the records associated with that piece of real estate. The conservation easement consists of a series of restrictions that essentially say thou shalt not do X, Y, and Z. And it's what's called a negative easement. It's a series of prohibitions. And the concept behind this is that these restrictions are designed to protect the significant conservation features and natural resources of the property itself. The kinds of features that I suspect are very much present on the county's lands have to do with agricultural lands, working farmland, if you will, working forest land that provides activity and potential income for the county, and provides to some degree service for folks in the county. There's obvious scenic value associated with undeveloped lands, especially when you have open fields and so on. Wildlife habitat is certainly a part of your property here. There may in fact be some rare or special species, plant or animal that might be found on this land, that depend on this land for their well-being. I don't know that to be true, but I'm speaking really conceptually at the moment. There may be areas of this property that help support high-quality water, both surficial waters as well as potential groundwater resources. It may also be a place that provides important outdoor recreational opportunities for the public. And whether that takes the form of existing trails that you might have or opportunities for hunting, for example, depending on what your policies or practices might be. So this is a typical kind of host of and mix of conservation resources. Peter, fill in on anything else that comes to mind instantly that fits within that basket.
There's some neat little wetland areas on the property.
Good.
I'm not aware of any vernal pools, but there
Yep.
might be some. There's some neat cultural features, cellar holes. The area was, I'm sure at the turn of the century, several centuries ago, was very active agriculturally.
Mhm.
So, I know those stone walls and cellar holes are part of the property.
Yeah, so some historical and cultural
Features.
features as well.
Cemeteries.
Yeah, cemeteries, sure.
Cemetery,
And those
that's right.
two can be part of and protected by the specific restrictions that are spelled out in the conservation easement. The fundamental premise of a conservation easement is that the owner of the land has the right to still do all the things that are not specifically restricted by the language and terms of the conservation easement. So whatever is not restricted remains within the prerogative of the landowner to do on the property. Still subject, of course, to other constraints that may exist in terms of ordinances or laws or rules or state requirements that may frame and govern and limit what any landowner can do. But that's the philosophical sort of concept and construct that makes up a conservation easement. The organization, the land trust, or in fact it could be a governmental entity that holds a conservation easement, receives this interest, receives this deed from the landowner. That group, whether it's a private land trust or a governmental entity, does not have the right to do all those things that the landowner has given up the right to do. And all that really the land trust or the easement holder gets is fundamentally the responsibility to monitor the use of that restricted land, to ensure that whatever's happening on the property, in fact, is not running afoul of those restrictions that are spelled out in the conservation easement deed. And if there ever is a problem, the easement holder has a responsibility to deal with finding some resolution of that problem. In effect, the easement holder is defending the land itself based on the restrictions initially set up. That is the fundamental and perpetual obligation that an easement holder takes on and promises at the time the easement is created. It's a big undertaking, it's a humble undertaking on the part of the receiving group, and certainly not entered into lightly. As well, for the landowner, it ought to be a humbling and very much eyes wide open step and process that's undertaken, because it is permanent. It's as permanent a thing as can be done on the land, with two exceptions. Conservation easements can be undone, if you will, in two situations. One is in the instance of a possible condemnation of the property by any governmental entity, whether that's the feds, the state, in fact, the county, or a municipality. All those entities, as you know, have the power of eminent domain, the power to take property, or in this case, take a conservation easement, as long as it's for a legitimate, demonstrated public good, public purpose, and also as long as the holder of that condemned real estate interest, whether that's the holder of the easement or the actual landowner, is compensated by the condemning authority, is compensated for the value of what it is that is condemned. So that's one case where an easement can be undone. Typically in New Hampshire, the most common instance of that we see has to do with roads, either road widening or maybe a new exit ramp off a highway. And it doesn't happen often. In the case of the Forest Society's 800 or so conservation easements, we will typically deal or come across a condemnation issue maybe once every 2 or 3 years. So not frequent, but you know, it happens. And typically it's because somebody wants to widen a road. They want to add 15 feet or straighten out a curve or something like that. That's typically not a terribly big deal, but we need to work through the technical mechanics of that process. The other instance, much more theoretical than condemnation, whereby a conservation easement can be undone, if you will, is if there were to be such a change in the conditions surrounding the conservation easement property that in fact those conditions, those changed conditions, removed the conservation significance that was there to start with, then the landowner could theoretically have a case to make before a judge to say, Your Honor, you know, this easement was set up primarily to protect a patch of the federally endangered small whorled begonias that used to be on this property. That's a federally endangered orchid species native to New Hampshire. And if the landowner is successful in convincing the judge that not only they're gone, but there's no prospect of them returning, the judge might then be willing to issue a formal decision allowing for the extinguishment of the conservation easement. We've never seen that happen in New Hampshire, and I'm not aware, in fact, of that ever happening across the country. But it's, so I underline, theoretically allowed under the IRS regulations that allow for the creation of these conservation easements. But I would put that in the pretty conceptual category. The much more practical issue has to do with condemnations that we see happen occasionally. So you'll probably ask, so what makes up the typical restrictions, to be more specific? And the not intended to be glib answer to that is that it really depends on which group you choose to convey a conservation easement to, because not all conservation easements are the same. There may be one group that places a great deal more importance on protection of natural habitat, and the Nature Conservancy is a good example of this, where they may place a higher priority on that. They may have more detailed restrictions about habitat protection than, for example, the Forest Society might. The point is, it's not a one-size-fits-all set of restrictions. I can tell you that for the Forest Society, the typical restrictions that you tend to see in the conservation easements we create nowadays would have the following kinds of things. First of all, there would be a statement that says no commercial uses or activities on the property with the exception of agriculture and forestry. Very important exception that fits with our sort of philosophical orientation and program and mission for the past 10 years old that we are, and what we've been about for a long time. Within that restriction, there are further details about how forest management gets done in terms of there needing to be a forest management plan in place that's been prepared by a licensed forester, and that any actual forestry operations on the ground need to be overseen by a licensed forester. And then finally, within that sort of subset of restrictions, references to the activities on the ground being conducted in accordance with what are generically referred to as best management practices. And there are different publications that articulate our sense of what good forestry practices are out on the ground that are referred to in the conservation easement document. The second typical provision and restriction in an easement would say something to the effect of no further subdivision of the property or separate conveyance of any of the parts of the property that make up the whole conservation easement area. Having said that, it's also an exception to which it's a restriction to which we sometimes make exception and can do so comfortably if there's a good rationale for the landowner wanting or needing that flexibility, maybe to someday split up the ownership of the property. Maybe it makes sense to take one part of your property and allow for separate conveyance of that to some other party at some future point. The point is, from our standpoint, as long as the resulting pieces resulting from a subdivision are still significantly large and sort of self-sufficient in its conservation importance, then we can work on and work with some kind of exception to the otherwise blanket prohibition about no subdivision of the property. So if that's an important thing for you all, by all means, we can talk about what how that exception might read. You know, what's the ultimate number of separate ownerships or tracts you would want, and in turn that we would be comfortable with if you wanted some flexibilities along those lines. Another typical provision would have to do with basically no manipulation of the natural topography of the property or water-related systems, no filling, no dredging, no mining, no excavation of materials. Again, with exception for what is typically agriculture and forestry. For example, if you want to be putting in tiling to help reduce the water within a field that you've got to make it more productive. That's a perfectly acceptable opportunity from our standpoint to be dredging and ditching and redirecting water flow for the agricultural component and purpose of the conservation easement. Similarly, if you were building a woods road through your property for enhancing your forest management access and activities, you may well need to cross some kind of a wet area or wetland, and as long as that crossing is done using the appropriate technology of the day, the best practices, then that could well be fine. But that's the kind of thing where we would want to be understanding the specific activities that you're undertaking basically to help ensure that in fact you've picked the least impacting site to cross some wet area, and that what you are doing indeed is in conformance with best practice for how to accomplish that kind of an improvement. Another typical restriction, essentially no buildings or structures or improvements on the property except in furtherance of, and again the mantra, agriculture, forestry, non-commercial outdoor recreational kinds of uses, and basically other direct conservation-related kinds of activities. So if, for example, you wanted to build a pole barn for farm equipment, if you wanted to build a sugar house, if you wanted to build a farm stand for your selling agricultural products, if you wanted to build a woods road, you wanted to put signage in for recreational use, you wanted to put in a walking bridge on a trail across some brook or wet area to get people over it. Those are all pretty straightforward structures and improvements that typically would be permitted under the terms of the easement. Again, there's kind of an overriding governor in the easement that says all those things are possible as long as they don't significantly impair other conservation features and purposes of the easement. So, if you're planning on putting the pole barn right smack in the middle of the most gorgeous view across your existing hayfield right next to the road, we might well ask, gee, could you perhaps put that off to the side of the field instead of right smack in the middle, so that we can minimize disruption to the scenic purpose and value of the easement, still enable you to do what you want to do, because it's on the face of it, it's a legitimate purpose that's in furtherance of your agricultural objective. But the point is, we would expect to have a little bit of give and take with you about a substantial project like that, basically to find that right fit between continued protection and enhancement of the purposes of the easement on the one hand, but on the other, still protecting the other resources and features that are there and that are intended to be protected by the terms of the easement. Let's see, another provision, another restriction, typically in the easement would say something along the lines of no conveyances of rights-of-ways or affirmative easements by the landowner to some third party without our approval first of that conveyance. This sometimes comes up where easement landowners get approached by a neighbor who comes to the landowner and says, gee, John, would you give to me a permanent right-of-way to cross through your property so I can put a driveway in and put a house back in on this lovely spot on my property, which is hard to get to with my own frontage because of some wetlands or something that intervene. And that's a situation where we want the ability to review that proposal, because frankly we're not likely to approve that kind of request, because the proposed impact on the easement area is the permanent installation of a residential driveway, which is not consistent with the purposes of the easement. In fact, it diminishes some of the features of the property in terms of the unbrokenness of the natural condition of our land. It's introducing human activity and comings and goings in a place that previously didn't have it, maybe disrupting the movement of wildlife and so on. Maybe it's going to get paved, which again is a further unwelcomed impact on natural conditions and features of the easement property. On the other hand, that neighbor might be saying, hey John, I'm doing a logging job on my property. Would you grant to me a temporary right-of-way for the next 3 months for my guys in the logging operation to come and go across your land to get into the back part of my property that otherwise they can't very easily get to. That's a kind of request that we are much more likely to say, sure, that sounds fine. We might well want to come out on the property and look at the proposed location for that temporary roadway just to make sure that it's not, running through some really sensitive area like a deer wintering area or something else that would be negatively impacted even just for the 3-month period. But that's an example where we would likely approve of that because the purpose of that right-of-way, being a forestry use, in fact is consistent with the overall objectives of the easement on your land. So that's another type of restriction. And then the final one that just comes to mind that's a very common one across many groups' easements, and I'm paraphrasing and shortening these for purposes of explanation, would be one that talks about basically no dumping or disposal of hazardous or man-made materials on the property. We have no problem whatsoever with things like brush piles and dirt piles and things that you might need to move around or that are normal in the course of forestry or ag operations or some other innocuous kind of use of the property. What we do not want to see is dumping of hazardous materials, and especially dumping by third parties that may be happening without, in fact, the landowner's knowledge or awareness or permission. So that's a pretty common set of standards that many of which you do see in other groups' easements, but not necessarily the same set. The next section of the easement has a really important part called reserved rights of the landowner. And this is an area where there may be some specific things that are spelled out which otherwise may not be specifically allowed under the limitations section that just preceded in the document. And we now routinely at least recommend that landowners think about including 2 types of reserved rights. One of them has to do with the installation of renewable energy production facilities. Because fundamentally, in fact, this is a conservation issue. It has to do with carbon footprint. It has to do with keeping energy supplies local. And it has to do with reducing impact on negative impacts on all of the resources that make up all the conservation lands in New Hampshire. And so if you have a desire to put in, for example, a ground-mounted solar array, then we want to be able to entertain that with some conditions or limitations in that, as before, if you're coming to us and planning on plopping that right smack in the most scenic part of your hayfield, right out in the middle, we might ask, gee, is there another site where you can still get good solar exposure, maybe compromise your exposure a little bit, but trading off for not having such a big impact on the views and the scenic values. We also do put some limits on the size and scope of an array. Typically, it's designed to meet whatever the current electrical needs are on the easement property. For example, if you had a sugar house or a dairy barn or some other electrically demanding purpose or use, then we want you to be able to meet those needs, and we also accommodate, although not necessarily applicable in this case with your property, but typically we will allow for additional inclusion of capacity to meet the needs of a single family residence that might be adjacent to the conservation easement area, because that's such a typical configuration and need and interest on the part of New Hampshire landowners. Again, you're a little bit of a different situation, and so we would want to talk through with you if you wanted additional capacity for related purposes on the county property. You know, we'd want to talk that through in terms of figuring out an appropriate way to limit it so that it's not simply a mega commercial operation that is way beyond the scope and scale of what anybody anticipated or wanted at the outset when we set this thing up.
Can I just
Yeah.
ask? That is something I believe the county is now looking at
Mhm.
early in the stages. And as you know, there are buildings here. There's the administration building, there's the nursing home, jail, and so forth. And who knows what other uses may be necessary in the next 5, 10, or 15 years. And so, if the property was in conservation easement, in looking at that capacity,
Mhm.
the county might very well now be able to determine what its electrical needs may be,
Mhm.
but the big question mark, what might they be 5, 10, 15, and 20 years from now? Could that be factored in as far as the capacity goes as well? I mean, if
Yep.
you're looking, saying, okay, this is what our needs are now,
Mhm.
but who knows what there might be down the road?
Yep. There are ways to
Yeah.
design limits
Yeah.
that are not absolutely fixed in time.
Okay.
And there are a couple of ways to do this that strike me right off. One of the things to do immediately in the process of thinking, where should the conservation easement fall on the ground, versus what areas do you want to leave out of the conservation
That
easement
was my question.
completely?
We can leave a 20-acre piece
Absolutely.
out of the easement.
Absolutely. And so what I would encourage you to do at the outset of your kind of planning and line drawing on maps is, first and foremost, leave out of the easement the most obvious places where you may have certain needs for expansion or potential new buildings or uses or intensive activities that really would not be terribly compatible with a conservation easement. The point is, give yourself enough elbow room right at the outset to accommodate the reasonable things that you can anticipate. And then maybe add some more for what you can't anticipate. The point is then that area excluded from the easement is completely open to whatever uses you might choose to make of it. Ken, I was just, before we started, Ken and I were looking at the map of the Stratford County farm conservation easement, and I highlighted on a reduced map that he's got an area that shows at the core of the property, right at the center where most of the buildings are and facilities. I delineated on that map the area that we, right at the outset, excluded completely. It's a fairly sizable area and percentage of the total. I don't remember the numbers offhand, but you can look at the map that Ken's got to sort of get a sense of how we approach that right at the outset.
It's about 70 acres.
70 that we excluded out of a total of, was it like 300?
313, I think.
Okay.
Is the number I want to
Something.
give.
Yeah. And it was right at the core. It took in all the existing
Right.
buildings and then added some areas as well for future possibilities, either known or unknown. So that's one response to how you build in capacity, because then you can put all the solar array or wind towers or anything else you want within those excluded areas. That's a non-issue as far as the easement area is concerned. Having said that, the other way in which we build in flexibility on capacity is that it's pretty safe to say that if you build a solar array today that's designed to meet the dairy barn and the sugar house needs, and the needs of your single-family residents adjacent to the easement area, whatever KW capacity that is. Let's say it's an array with a ground-mounted array with 40 of the standard, what size are they? I forget, 3x5 panels. I mean, I've got them at home and I can't remember exactly, but let's say it's 40 of those panels on a rack. I can say with some confidence that as time goes on, if and when we or future owners of my home property want to replace those panels in 20 years, they will be able to generate a whole lot more electricity from panels with that surface area, because there's only one direction this whole technology is going, and that is smaller and more efficient. So that's a way, without changing the physical size of the array once it's put in place, you're almost assured of greater capacity down the road simply because of technological innovation continuing to drive in the direction of smaller and more efficient. So that's another way. And there may be some other devices that we can creatively come up with to accommodate potential expansion as well.
Follow-up question on that.
Yep.
Okay, you had mentioned that looking at our maybe energy needs here for the county buildings in the county itself. You might be a little apprehensive if all of a sudden you felt that meeting those energy needs, we were looking at more commercializing this, maybe putting energy out in the grid. Okay, so, but following up on the comment that you made, technology is basically going to be keeping ahead of this. So now the land that had been set aside 20 years ago now has got to be replaced. But the technology has advanced so much that just using the space that was allowed, now maybe we could produce 2 or 3 times the power that we needed.
Right.
On the same space.
Right.
Would that allow the county then to say, okay, we can produce significantly more energy than we needed on the same space? Could the county then go out and say, now we want to commercialize that. We want to put
Sure.
that into the grid.
Sure, because frankly, from the standpoint of impact,
Yeah.
there's zero change
That's right.
in the impact on the conservation area and land. I mean, a cable's a cable running from your array into the grid. And if you've installed a cable to start with and you're using that same cable, I mean, yeah, maybe you need to put in a slightly larger cable, but the
Yeah.
point is, there's not a significant change in impact on the ground, if
Okay,
you will.
okay.
And that's where we're
If
going
that
to.
originally wasn't part of the easement, you'd have no say over it
And it's a
whatsoever
non,
anyway.
exactly, it's a non-issue
Exactly,
if you
yeah.
find a better site. So, you know, you have the tops,
Revenue producing.
you have the roofs of your existing buildings without knowing whether they're well-oriented or not.
Yeah.
But that's the kind of thing that I suggest you think well about when you're doing the initial sort of line drawing of preliminary ideas for exclusion area versus what's in the easement. The bottom line is we want to allow for some reasonable accommodation for renewable energy facilities within the easement area if you find that, you know, you're not able to do all that you want in that regard within the exclusion area. So the other reserved right that we encourage you to think about, we don't force this down anyone's throat, but we think it's a smart approach. We actually have a provision that says as a reserved right that the landowner is entitled to undertake other commercial activities on the easement land as long as the impacts of those activities are de minimis,
Where's that?
Latin for minimal.
Okay.
And what we do is then spell out a process by which, if you have some proposed activity that's not clearly agriculture, it's not clearly forestry, because those things are already provided for as exceptions to the no commercial use limitation. If you've got something else you want to do that does involve, has a commercial component to it, then we're not going to automatically say, no, you can't do that, which is frankly what we have had to say on some of our older easements that didn't take this approach.
Uh-huh.
Instead, we lay out a process by which if you have a proposal that you want to make, we're going to ask for enough detailed information about what it is you want to do, what's the scope and scale and intensity and frequency and, description of what you're proposing to do, so that we can then make some assessment of whether or not this is going to have a significant negative or not impact on the conservation resources. And a very common example that we're seeing, or a category of example that we're seeing a lot of nowadays, things that very creative farmers are doing on their land that really have nothing to do with farming, but that provide very helpful additional income sources to their operation. Hay rides. If you look at a hay ride in absolute terms, that's not an agricultural activity of people climbing on a hay wagon and going around the perimeter of the farm and paying to do that. And we would view that under our easement language, that's a commercial activity at its core. Yes, of course, it's helpful to the farmer. Yes, it's putting more money in the farmer's pocket. Yes, it helps farming remain on the land and be economically viable and all of that. But we view that as a commercial activity. It's probably a nominal impact, negligible impact, and so very good chance that we would say that's fine in terms of allowing the landowner to do that. Woodland owners, dog sled, trips in the wintertime on an existing trail system. It's hard to say that there would be any negative impact per se of that activity, but it's not a forestry activity. It's taking advantage of forest resources and the trails or woods roads that resulted from forest management. But it's a stretch to say that's forestry. We don't want to frustrate that kind of creative, low impact sort of use. And so we set out a process by which the landowner can make a proposal, we can evaluate that and make some decision about whether or not we think that's okay, and we'll provide something in writing which then the landowner can rely on, assuming it's approval, for actually implementing and undertaking whatever that activity might be. You had a question.
What kinds of agritourism activities would you be less likely to approve?
One example that we've seen happen down in the southeastern part of the state, we've seen haunted houses be constructed on farms. In fact, attracting hundreds and hundreds of people every day during fall weekends. And to the point where there have been really serious impacts on that farm operation, especially relating to things like parking. If you're parking hundreds of vehicles repeatedly on farm fields, that's not doing the soil much good in terms of compaction. There may be leakage from some of those cars in terms of oils or other fluids. That's generally not a great thing. On a scale, it has to do with scale, because if a landowner comes to us and says, look, I want to rent my place out for one weekend a year for a wedding, which involves parking and tents and caterers and hoopla, we might well say, well, that looks fine, because the scope and scale of that is really not something that we would envision being of significantly negative, problem to the land. But when that gets carried through to every, half the weekends of the year, and we're talking about hundreds and hundreds of people flowing through a farm property for a use that is not a farming use per se, we're going to start asking more questions and looking more closely at impact.
So these are activities that let's say the county designated this part was going to be for farming, then you would have this oversight. But if this is a connecting parcel to your parcel, you have no control over that.
Correct.
Correct.
Is that what you're telling me?
Yeah.
I'm not sure what you mean
I'm
by
saying
connecting
let's-
parcel to my
okay,
parcel.
so let's say the county
Yeah.
removed 100 acres.
Excluded.
Yeah,
Right.
excluded.
Yeah.
And your easement started on the back side of that.
Yep.
And let's say the county did want to deal in weddings, it wanted to do a concert or whatever.
You wanted to have the service.
But it was not, nothing, no activity entered the conservation easement.
Right.
You don't have a say over what happens
Correct.
on my
Okay.
neighbor's property.
Correct,
Okay.
yeah.
That was a
It's-
question that I-
It's a
That's
non,
fine. Yeah.
it's a
Okay.
non-issue from
Right.
our
These would be
standpoint.
activities
Yeah.
that had been permissible to be on the easement land, but they were expanding the use to something that may not be of benefit to the conservation easement. That's what you were speaking of. So someone, you allowed someone to go in there and have trees for, maple trees for a sugaring operation, then all of a sudden they decided it was going to be a breakfast spot also. You would have say over that.
Right,
Yes,
right.
okay, I
Right.
understand. Yep.
And they're also, you know, the term agritourism is a really dangerous term, I
Quite open.
suggest.
Yeah.
Oh my goodness. I encourage you to go read the state statute, the definition that in fact got revised within the last couple of years. It is remarkable how wide open that definition is. We don't want to have an easement relying on a term like that that is so completely open-ended in terms of possibilities. And that's why we deliberately exclude that word from our easement, and we have come up with what we think is a tighter, I'll say more pure,
Okay.
dangerously perhaps, more pure definition of what we think agriculture and forestry mean. And then if somebody wants to propose something that's outside of those bounds, it's very likely going to fall within this bucket of a commercial activity for which they might well get our approval under this second reserved right system. But the landowner has to demonstrate to us that what's proposed to happen is really not going to have major negative impacts on the conservation features of the property.
Another question, let's say that there are a few existing trails on the property, which is under a conservation easement, and the landowner is trying to open it up for additional walking trails.
Mm-hmm.
Would they be permitted to build a new trail?
Sure, it's an outdoor recreational use.
All right, so
And-
trail does not exist at all, so it means trees have to be come down and maybe some grading, depending on the expected users of that trail.
Mhm. The only kind of thing that we're going to be interested in is, as you recall from my earlier comments, kind of that overarching qualifier that you can do these things as long as what you're proposing to do is not detrimental to the purposes of the easement. So our interest, if you're going to build a new trail through your woodlands or fields or whatever, we would like to probably see what you're proposing to do where, and be satisfied that you're not just simply taking your backhoe and filling in a wetland to create an elevated causeway for a trail to conveniently cross the wetland. Because that's probably not going to be either legal or certainly done in accordance with best practice.
I would agree with you there.
Yeah. So other than that kind of fairly egregious problem or impact, if someone wants to cut some trees to extend or create a walking trail through their property, we're going to be pretty unexcited about that. And we might well even just say, if based on your description of what you're proposing to do, it may even be something that we don't even come and look at, but just converse over the phone. You maybe send us a little map showing what you're proposing to do, one of our easement stewards looks at it, looks straightforward, and we'll say, great, go to it.
What about other modes of transportation, let me put it this way, across those
Motorized.
trails?
Yeah.
No. How about bikes,
Yeah,
Oh, no.
equine,
yeah.
carriages perhaps?
These are all probably falling within the realm of outdoor recreational
Fine.
activities or uses. And the same set of interests and disinterests on our part would probably apply. It doesn't matter from our standpoint whether you're building a snowmobile trail or whether you're building a walking trail. What we're going to be interested in is, what's the overall purpose here of what you're proposing to do? Is it a commercial or not a commercial activity? And then thirdly, what are the potential impacts? And if based on the mapping and information you've given to us suggests that, this trail is not running through super sensitive areas, wetlands, deer yards, some other place that mattered when we set up the conservation easement, then you're very likely to hear from us, go for it. And in fact, we may well not even have a formal approval process because that falls within what we structure, as you would see in our standard easements, a by right kind of use. In other words, you don't have to get our approval to build a trail. If you had a question about whether it was appropriate, we welcome, of course, you to call us and just check in with one of our easement stewards if you thought you had a question. The bottom line is, we're coming out and checking on the property. We monitor our properties annually. That's our obligation. And annual monitoring by us may involve aerial photography, so you actually may never know that we came and went. But
The drones.
on the ground, we ensure that we have visited every one of our easement properties, typically every 1 to 3 years, and we do that, with a request to go out there with the landowner. We want to build and maintain a positive working relationship with the landowner. It's not in our interest to go into these things with an adversarial sort of relationship because we're in it for the long haul. And the best way to prevent problems is to build and maintain a relationship that's based on good communication and trust and respect for one another. And that sort of governs how we relate to our landowners. We're not trying to sneak around checking on things or enforcing things without your being aware of what we're doing. We're wanting to be on the land with you, hearing what your issues and concerns are. Maybe you're struggling with some usage to do with the public or some third party. We may well be able to help you deal with a problem because of resources that we can help bring to bear, or knowledge or information or other grant sources that you can apply for to solve your problem. We're interested in helping you be the best managers and landowners you can be. That's in our interest as well as yours.
Amanda, you've been very patient.
Yeah, you've given us all the negative things of having Big Brother watching over us, etc. What are some of the positive reasons to have a conservation easement?
Several, I would suggest. One is that in the case of the county lands, you've got some very productive both agricultural lands and very productive woodlands. And one of the things that a conservation easement can do is give a whole lot more certainty looking into the future that these lands are going to continue to be available for those kinds of uses and activities. If the county is looking to bring others in on the county lands to do entrepreneurial and creative kinds of activities, in the name of agriculture or forestry or something else, it would be well understandable by those other parties coming in that they would want to be confident that once they vest themselves in whatever the activity is, they don't want to run the risk of finding out next year that the county has just decided to terminate, that use because they're going to use that same piece of ground for an enlargement of the nursing home or whatever it is that you might legitimately want to be able to do. So that uncertainty will, I suggest, hold back people I think you're interested in bringing onto your land to do some pretty darn interesting, creative, long-term stuff that could be of great benefit to the county and its people. That conservation easement adds certainty and confidence about the future use and availability of the property. So that's, I would suggest, one big plus. The other pluses are, or some of them anyway, would relate to simply the protection of the significant resources that you have on the county property, whether that's, again, hunting, and whether you want to provide opportunities for continued hunting for deer or other species on your land, an opportunity that you can give to county residents, protection of related habitat, protection of water quality. These are things that have public benefit and goods associated with them. Continued availability of forest management activity and the income that generates. And knowing that people operating on the land can take the long view in how they manage the property, because they don't have to worry that 20 years out their hard efforts to thin and improve a stand are all going to be wasted because that site's now going to become, a new building for X, Y, and Z. And all of that hard-worked thinning and improvement of a stand to produce something that you are looking forward to reaping and realizing in the future, it may all be for naught if, again, the county were to change its mind with a non-easement area and convert it to something else completely. Same with agriculture, as I said. Peter, help me out with any other benefits or pluses that I haven't mentioned, if you think of any.
Yeah, well, that's probably the major one that comes to mind for me, but I know I'm a proponent of easements, and what's concerned me is, having been here forever, is this concept of selling the property rears its ugly head periodically, and it depends on who's currently our representatives. I know the current board, as I understand, have voiced the opinion they're not interested in selling the property. And I know with an easement that doesn't prevent you from selling, but it does prevent the development of the land, which, bottom line, I think is of ultimate concern. So with the easement, it would provide the assurance that this 900-acre area minus the excluded area that needs to be, as mentioned here, adequate in size to accommodate all the future anticipated growth that we can envision. But the protection of the remainder of the acreage from development, not necessarily the sale of it, would be important. Hopefully the county and future representatives would never consider selling the property. I mean, I would love to see it remain county lands and be a major protected green space for forestry and agriculture forever. Forever's a long time, so.
Yeah. So one other benefit, you just touched on this a little bit, to the extent that there is a potential holder of the easement that's willing to buy that conservation easement from you as the county, that can create a bump of helpful income to the county for some part of the value of that conservation easement. And that income presents an opportunity for the county to do any number of things. You know, whether you choose to plow it simply into operations, or you plow it into and reinvest it in fact, some of the land-based activities that you're interested in fostering or enhancing. Those are all options that you would have for use of any funds that might be able to pass across the table at a conservation easement closing.
Are they substantial?
It's hard to say that because how much money, let me back up for a moment. There first needs to be, for talking about money, there really needs to be an appraisal done of the value of the proposed conservation easement to know what in fact the dollar figure is that represents the financial value of a conservation easement. Because until you have a number like that, you know, we may have 8 different ideas around this table about what we think an easement might be worth on the county lands. And before you can do an appraisal, you have to be able to give the appraiser a map that says this is the proposed area for the conservation easement. And in other words, this area over here is to be excluded from the easement. That's really critical for an appraiser to put a dollar figure in place. And the appraiser needs to have at least a draft of the conservation easement terms, because unless you know what those details are about the restrictions and the reserved rights, the appraiser is really not going to have any clear basis on which to come up with a dollar figure. So having said that, the other big factors that come into play in how much money might actually cross a table at an easement closing is whether in fact there is a group that is willing to pony up serious dollars to buy a conservation easement from you. I can assure you there's not a long list of conservation groups with lots of money just waiting to buy an easement on this and many other properties around New Hampshire. There has to be kind of a marriage of interests here. There has to be a land trust or group willing to make a significant effort to raise funds through typically combination of grant funding sources and maybe private contributions to raise enough money to purchase a conservation easement and to provide for the long-term stewardship of that easement as well. And many times, most of the time, most of the conservation easements that are sold in New Hampshire are sold at what's called a bargain sale price. In other words, a price that's lower than the appraised value of the conservation easement. And typically that's simply a reflection of the fact that there's what funds there are, grant funds there are for funding land conservation projects in New Hampshire are extremely competitive. The Land and Community Heritage Investment Program, LCHIP, as you may have heard, has incredibly tight competition for whatever it is, the $3 or so million, $2 to $3 million that they have available each year. It's a great program, and frankly, I would expect that it might contribute something to a project here, but they're not going to fully fund a full value conservation easement, nor is it likely that a land trust group is going to be able to come up with all the money that would be needed to pay a price that's equal to that full value of the conservation easement. So the next sort of neat question is, okay, well, if it's below value, the price, how do you set that price? And all I can say is it's a negotiation. It's a back and forth. It's a finding of right balance point between, on the one hand, for the feasibility for the land trust group, they've got the serious obligation of coming up with X dollars, whatever X dollars is, and are they going to be able to do that? And it's, all I can say is it's not easy to raise funds in a big project, for a big project, and especially for a big conservation easement project.
Would this be considered a big project?
Yeah, because it's it probably is going to be a large acreage involving some hundreds of acres, you know, and I don't know whether you're thinking 600 or 400 or something, but it's going to be a significant project, probably involving some significant money, regardless of where we or another group might reach an agreement with you on price. I'm making the automatic assumption that there is going to be a purchase price, as opposed to your choosing just to give us a conservation easement. We would, of course, be delighted if you chose to do that. And frankly, it makes it way simpler and so on. But we fully appreciate the fact that the delegation, you know, the delegation has a fiduciary obligation here not to be taking actions that fundamentally jeopardize future options and possibilities. And of course, that's what a conservation easement does, it does jeopardize and limit future options. But the money that you would receive in compensation, at least partially, for the conservation easement helps offset that issue, because then the money presents new opportunities for you to do things that previously you didn't have to work with. So, you know, there's a balanced point here between feasibility for the land trust and workability for the landowner to accept enough of a discount to make it work for the land trust, but also enough money to satisfy the decision makers, you know, that they're getting something significant out of this transaction that enables new opportunities and decisions to be made.
A follow-up to that. These land trust transactions, are they all public?
Yes.
So you must have some collective evidence over the past 10 years or so as to a percentage of the appraised easement value that's actually being paid.
It runs. There's no trend, if you will. You'll find.
Now I'm a mathematician. You add them up and you divide by the number.
Well, I mean, you can come up with a number, but every one of these projects is so different. And, you know, we're dealing with private landowners, we're dealing with municipalities, we're dealing with the state of New Hampshire. It gets a little bit hard to throw them all into one bucket and do the math and say that, you know, on average, a bargain sale occurs at, you know, 43% of fair market value. I mean, we can, you know, anyone can arrive at a statistic like that, but the applicability of that to this situation here is, I would suggest, a little bit suspect, because there may be factors that matter to you about how much money you receive or don't receive that are not at all important to other landowners with whom we might have done business on purchasing a conservation easement. So it just, all I can say is it runs the complete gamut. I mean, we've done bargain purchases for 10% of the fair market value, and we have done purchases of easements and lands at full value, and everything in between.
Tom, if the county were to place an easement on a portion of the property, what are the major expenses that they incur as a result of that exercise? You mentioned they have to have a survey.
Right, there does need to be a survey done of
A stewardship.
the easement area, because it's important for everybody to be clear. The easement falls on this side of the line, and this line is on the ground that we can see and determine and be clear about, and it does not cover the area on this other side of the line, whether that line is a stone wall or whether it's pins put in the ground with a defined course between it. So a survey is a really important tool for everybody. Who pays for that survey is negotiable. And sometimes the easement holder may be willing to pay for it and in effect cover the cost of that within the fundraising campaign as a transaction cost that is covered by the fundraising efforts. On the other hand, the landowner may be in a position to do it. Sometimes landowners have relationships with surveyors or can get a better deal on getting a big project done than we could get by simply going out and hiring somebody. There may be any number of reasons why one or the other parties might cover that, but it's a need and can be an expensive step. There has to be an appraisal done of the conservation easement. We have to have an appraisal if we're going to be buying something, but many times it's in the landowner's interest as well to know what is the value of that conservation easement before talking too much turkey about price, because until you get that appraisal, everybody's kind of floating around all over the place in terms of expectations and ideas without being grounded. One of the things we've often done with landowners is go in 50-50 on splitting the cost of an appraisal relatively early in a project. And that's just simply reflecting the fact that it's in both parties' interest to have a good idea of what a competent appraiser thinks this easement's worth. And it reduces the risk for both of us, because if things don't work out, well, you got a good appraisal for half the normal cost. Same for us. Yeah, we lost a little money because things didn't work out, but it's kind of a fair and reasonable way to get that important step accomplished early on. We also need to cover our own other transaction-related expenses. For example, the time I spend working on an easement project. It's very common for me to spend at least 60, 80, and sometimes many hundreds of hours on any given easement project. And our organization needs to find the funding from someplace or other to cover my time for the project. And that's often part of, again, what we roll into a fundraising goal or campaign. Some landowners are in a position to be able to compensate us for that and cover it. And we, of course, are delighted with that because it makes the whole project more feasible for us to have a lower goal financially that we have to raise. Let's see, what else? Long-term stewardship is another financial component of the puzzle that needs to be put in place some way or other in any good, responsible conservation easement creation.
To define long-term stewardship.
These are funds to cover the 2 or 3 kinds of activities that we undertake, any land trust, any easement holder would undertake once an easement is signed and set up. So we mentioned first the fact that that group has the annual monitoring to do. That means time and therefore cost. Whether we're doing it by air, we pay, I forget if our overall contract, it's like a couple of $100,000 a year for aerial monitoring. Now granted, for our total array of 800 or so properties, but the point is whether it's done on foot by people or air or something in between, that's cost, the annual routine stuff. Secondly is the maintaining of relationship with the landowner. Very commonly landowners will call us up or neighbors will call us up and say, hey, there's a cement truck pouring concrete in the middle of the field that I thought was under conservation easement. What's up with that? Or the landowner himself or herself says, I'm thinking about building a such and such on my property. Is that something I can do? So we have a responsibility to follow up, to communicate, to check into things, and most of the time it's not a problem per se, but it's a matter of time and effort to communicate and educate and inform one another about what's happening or what's proposed to happen. That's the ongoing kind of relationship building that we do. And then the third component that can be far and away the most expensive is if in fact there is some enforcement action that we have to take or that we get caught up in as a result of our holding the conservation easement. The most expensive easement violation case, court case, and we've been involved in, I'm guessing maybe 5 or 6 court cases so far in our history over easements, maybe 8, something like that. The most expensive one, which actually we didn't even initiate, it was initiated by a neighbor and a butter to a conservation easement area that sued the landowner, and it sued the easement holder and the backup easement holder. And we happened to hold the so-called backup or executory interest in that easement. We ended up shelling out about $130,000 in just legal and court costs for that case. That doesn't even count the huge staff time that we spent over a couple of years dealing with that problem and situation. I suppose you could say that the Northern Pass fight that we waged, involving a whole lot more money than that, in some respects that has been a stewardship issue, because the proposed route was proposed to go through and over lands that we own and have legal rights in. So part of what we've been doing with that very public fight is defending our lands and conservation easements from a use that we believe is fundamentally contrary to what is allowed under the terms of these conservation easements, and or just simple, proposed trespass and violation of our property rights. I mean, that's one perspective, and I realize there are a lot of other perspectives about Northern Pass, but just to help you get the sense, these can be very expensive issues, and we have to be prepared. Our obligation is to be prepared to go to bat, if we have to, on each and every one of these easements, to do our darndest to uphold those restrictions, because that's the commitment we made when we signed on at the time of the easement creation. And we can bring to bear all of the pooled conservation resource funds, the endowment and stewardship funds that have been added to over a whole lot of decades. We can bring to bear fairly sizable amounts of money and effort and legal defense, if we have to defend those restrictions. And the fact that we can do that, and that we keep adding to and growing that pool of financial resource, that's of comfort to landowners who are wanting to consider setting these things up with us, because it gives the landowner confidence that we're going to deliver. If push comes to shove, we've not been able to resolve an issue using common sense and reasonable approach, which is always our first line of approach. But as a last resort, if we have to go to court or get caught up in a court situation, a legal situation, we're going to do our darndest to defend that easement using all the resources we have available. And that's where this easement stewardship funding comes into play, both in terms of building endowment funds that spin off a little bit every year for the routine things, but also a piece of that going into a legal defense fund, all of which we can spend if necessary for any given easement problem that might come up. Other expenses, we have our own legal expenses. A landowner we recommend should engage their own attorney for reviewing documents. We will prepare draft conservation easements. We can't force a landowner to have their own attorney look at stuff for them. We highly encourage it. So that's a potential expense for the landowner. I think I've covered the waterfront appraisal, survey, legal expense, our transaction costs, our stewardship, long-term stewardship expenses. I think that covers the typical array of costs that one way or the other need to be addressed or accommodated. Again, some of those may be negotiable as to who covers it and how it gets covered. But our obligation is to make sure it's covered somehow. Ken?
So Tom, I can remember down in Stratford, there was a lot of power lines down there, as we have here, a big swath of power lines.
Yep.
Now, how does the easement affect the maintaining of those power lines by the power crews?
It doesn't affect it at all, and that's because the right to have those power lines going through your property is a pre-existing, it's an existing legal right. And there's a document, probably at the Registry of Deeds, a utility easement to, New Hampshire Electric Co-op or Public Service, Eversource, whatever it was at the time. And if you read the fine print in those utility easements, it says things like not only the right to install and maintain towers or bury lines or whatever, but things like the right to maintain the vegetation, as in cut vegetation, within the prescribed width, defined width of the right-of-way for purpose of maintaining the lines. So as long as that utility easement was recorded at the registry before the conservation easement, then the conservation easement restrictions are subject to all prior rights of record. Okay. Whether it's the utility company or somebody who has a legal right to drive through your property to get to their property, a right-of-way, the easement can't alter existing rights that may have been already set up.
Okay. Question. I just want this for clarification here. I think you've explained it, but I just want to be sure. County land that was not put under conservation easements, then the easement would have absolutely no restrictions and limitations on that land at all. In other words, the county would be free to do whatever it wanted to do with the land that was not under conservation easement. Mm-hmm. Okay. The other question is, say that the county felt that there was a need to do something on a piece of property that was not on conservation easement, but aborted land that was. And you felt, you being the holdup, felt that that was somehow a threat, could be seen as a threat to the land that was under conservation easement. Could you have any impact or say in questioning that use?
It's an interesting question. We would be very hard pressed to have a right to step in, because as long as the activity that you're undertaking
it's legal,
is grounded literally on the area that is not subject to the easement.
Yep.
Then we have very little to stand on to somehow complain about or have a beef with what I might say are spillover effects.
Okay. All right.
Okay, here's an example. Let's say you want, I'm exaggerating to make the point, but I think it's instructive. Let's say that you want to have, Circus Smirkus come and perform every year on your field that's excluded from the easement. Or you want to have a car rally, or Lord knows what else. And what's proposed to happen is really noisy, really noisy. One could argue that there are some noise impacts that do affect the conservation easement area, maybe that push wildlife off the property. I'm reaching here a little bit because it would be a little hard to imagine something so extreme, although I suppose you don't have to go farther than the Loudon racetrack to find such examples. But even so, I think we would have it would be very difficult for us to claim standing on the basis of the easement, I think, that somehow we can cause what you're doing on your side of the line, where we have no legal restrictions in place, that somehow you have to limit what you're up to. You know, maybe there's a case that ties in with existing rights of neighbors under just conventional law and court case, where neighbors are entitled to some degree of privacy or peace and quiet. And I'm reaching here, I'm not an attorney, but you know, if somebody's doing something next to your home or residence that is so completely obnoxious that you can't sleep at night and you can't do this, that, or the other thing, I think there is some legal recourse you can take for requesting a court to limit the activities of the abutter. But barring something like that, the easement is confined just to the easement area, and that is where we have to focus our attention and enforcement provisions. One other thing to add, and this is just sort of adding a little nuance to all of this, but in terms of options, we sometimes do easements that have different zones for different levels of restriction. So we might have, and this was done, for example, with some of you, any of you been to the Boy Scout camp in Gilmanton and the Belknaps, the Webster, Daniel Webster, big camp there, 3,000 acres. It's under, the whole property is under conservation easement. But that easement's held by the state. But there are different zones set up for different levels of restriction. And the one zone that takes in pretty much the whole built area, kind of the core operation of the camps, you know, where there are all sorts of buildings and dormitories and cabins and dining halls and parking lots and septic systems, you know, it's pretty open in terms of what's allowed, as long as what's allowed is still in furtherance of a youth camping operation. And so that becomes the limitation. What's not allowed is a pure commercial enterprise or something, some other completely different use. And so one of the things you could think about, and again, I can help, or others can help you with this, there may be certain approaches you want to take where you don't want the full set of conservation restrictions on all the land that you're considering under easement, but maybe, you know, in setting up what's excluded versus what's subject to the easement, there may be a couple of different types of level of restriction that you want to consider for your easement area, where maybe there's a little more freedom or flexibility to do certain kinds of things within a certain zone that's adjacent to the exclusion area that still gives rise to protecting fundamental resources and natural features and so on, and that's worth our while to hold as a conservation easement because it's still preventing certain kinds of uses that would be problematic for that land. But that gives you more opportunity and flexibility than what might be conceptually the outer ring, the most remote areas where you might expect to see a fuller set of conventional restrictions. I just mention that because it's a tool that sometimes can be a helpful way to construct what it is that, you know, you're after and that's acceptable and workable for us.
Amanda?
What about the change of use? What if you have a field and you turn it into a forest, or you have a forest and you turn it into a field?
If you want to let a field grow into forest, there's no issue to do with the easement whatsoever, in that the easement doesn't mandate that you must continue to maintain an agricultural operation or field in that use. In other words, if you want to let it go to trees naturally, that's fine. You're not
No,
gonna-
I'm talking about planting, like planting Christmas trees or planting pine trees, or
That's fine. That's
or going
fine.
into a pine forest and cutting it down and stumping it and putting in a field.
If you want to go the other direction, you want to create a field from forest land, then what we're going to want to do is basically, it's not prohibited to do that. But what we want to see is evidence that you've got a thoughtful plan about what you're going to do and how you're going to do it. We've seen situations and been approached by landowners who said, I'm planning on making a field out of my woods. And they go out and they bring in a lowball logger who absolutely liquidates every stick of wood on a big area. And then lo and behold, the landowner sells the property or sort of disappears from the scene without having removed the stumps or done anything to actually create the field. In other words, it was kind of a ruse for a liquidation cut, which is not a result that we think is a good one. And so we want to see some evidence that indeed you have a plan. There may be a NRCS involvement in development of new fields, and typically they would expect there to be an agricultural management plan in place that lays out how this is going to happen and where it's going to happen and a schedule for it to happen and so on. So as long as we see some reasonable evidence that you're going to follow through, you've thought this out, you're going to deliver on your overall plan, then go for it. Great. If you're willing to create a new field where there hasn't been one for a really long time, that's fantastic. It's a great, wonderful new investment because there are very few people, landowners, doing that. So often it's going in the other direction. And if there's great prime ag soil that you want to capitalize on that's covered in trees right now, what a great opportunity for taking advantage of really highly productive soil that you may have that was last used for agriculture 200 years ago. That represents a great opportunity.
But if I could, so those are things the county needs to think about. So if there's a forest that could be contiguous to an agricultural use that's there now, then it would be in the county's interest to keep that and not turn it over.
Exactly.
Because I'm assuming, let's say we turn this over to Christmas trees production.
Right.
When it comes time to sell those Christmas trees, the county's not, you're gonna have to get a bite of that apple.
No?
You're not gonna take anything from that.
Oh, we wouldn't complain if we made a contribution, but no, we're not entitled to any of the income
source, okay.
that you're
As long as it
generating.
was set up ahead of time.
Yeah.
Yeah, I mean, it's you're the landowner, and you're undertaking the activity, and if you're generating income from that activity, terrific. We hope that you'll use some of that income for literally or figuratively plowing back into enhancing good management of the land, but that's not for us to dictate, that's your choice. You could
So-
choose to spend it on building a building somewhere.
So let's say, for instance, 500 acres was put into this conservancy.
Yeah,
The owner of those 500 acres is you,
no, you,
it's still us.
You're the owner.
You're still the owner.
So comes time that line runs down through there and the county has some commercial operation that comes in and says they could build something on the other side of
The
the county side.
excluded area.
And so the zoning notices go out. It's not a complete municipal operation.
Right.
Are you noticed of that activity or just the county at that time? Because then that does give you standing. If you're noticed, you show up and you say, geez, I don't think this is in the best interest, and now you've had a much bigger play in that hearing.
Whether we're noticed or not tends to vary town by town. Towns that have their act together and do a good job of mapping and so on. I believe, I could stand corrected on this, I think under state law, this was a change that got put in place about 15 or 20 years ago. I think that the holder of a conservation easement is entitled to receive notice
I believe they are.
of a proposed subdivision of adjoining or the same land. The practical reality is the town or the landowner may not necessarily be on top of that, depending on like whether the tax maps and the town information is sophisticated enough to show easement holders on top of the actual landowner in that location. But theoretically, we should get notified, and you know, all we're doing in looking at a subdivision notice is, I mean, what we're interested in is, does this have to do with subdivision of the easement land itself or not? Because if it doesn't, then we have no interest in what that's about, because it's adjacent and excluded land that is not part of the conservation easement.
But
If,
it
on the
could-
other hand, there's a proposal to subdivide the easement area itself, then we're gonna look very quickly to see what's in the easement terms, and did we allow for some exception to the otherwise prohibition against all subdivision. And then maybe there is an exception that allows, and we just want to make sure that what's proposed is consistent with what the written exception was.
Amanda, you,
Yeah, I had a question. If, following up on Max, if we proposed a subdivision and building some stuff, and you were notified as the adjacent easement holder, would you come and do investigations to see if there was gonna be a water runoff problem, or it was gonna create a problem on the easement land, things of that nature?
We might, but probably not. I mean, it depends on what you're proposing to do. If you were proposing to build substantial buildings right close to the easement boundary line, then we're probably gonna be wanting to pay some attention to the details of the proposal, and basically to remind everybody, keep your activities on this side of the line. Maybe we would come out at some point during construction just to make sure that the people actually, you know, digging the dirt and doing the building are respecting our boundary lines. But on the other hand, if you're proposing something that's a long ways away and we have no particular concern about what's proposed potentially impacting our interests, I doubt that we would take very much interest or spend much time being involved in that, because on the face of it, it doesn't look like there's a potential for that to happen. It sort of boils down to common sense and what the specifics are of the situation as to how involved or uninvolved we would be in something that's proposed.
I want to follow up on this,
Yep.
Say that in the future, the county decided to, on land that was not excluded, they could do what they wanted on this property. And they went forward and they're going to be putting up another building and doing whatever use. They went through the whole process.
Mm-hmm.
And the holder was never notified. And they got approval from the municipality to go ahead and do this, and they started construction, and all of a sudden, the holder finds out about it and says, you know, we've got some concerns here about the impact this may be on land that is restricted. And we were never notified. Could they then come forward and say legally, we were never notified, and as quote, defining a butter very loosely, and we've got some questions about this, and could they derail and stop the whole project?
You're asking more of a legal question,
Okay.
and I don't know the answer to that. What I can say is we're not interested in jumping into some situation right away as an adversary. We're always going to be interested first in being pretty commonsensical as neighbors and partners in this thing. You know, we're going to want to get more information if we find out about something. Just because there's the technical ability
Yeah.
to halt a process because we weren't notified, that does not mean, and I hope in most cases would not cause us to instantly exercise that right just because we have the power to do it. That doesn't promote a good resolution of a problem, even though technically we could. But that's playing hardball right off the bat. And in our general experience, you don't tend to get good resolutions with, you know, an amicable parting of the ways at the end of a situation. You don't get that when you go in playing hardball right off. We want to use common sense, good communication. Yeah, there may have been a problem or a screw up, but we're going to be more focused on, look, what's the issue that we're concerned about, not the procedural stuff that did or didn't happen, and what can we do, what's the issue, what can we learn about potential impacts, what can be done to lessen our concern if we think these impacts are real or not. And that's the kind of approach that's the way we operate.
Okay.
And it's the way, heaven forbid, we should operate. And if we're not operating that way, we're really not doing our job smartly, because that's the way you maintain a good partnership and relationship over the long haul. You don't butt heads just because you can.
Okay.
You butt heads only because you have to, as a last resort.
So Tom, thank you for saying that, because I had a great relationship with your land stewards over the years. And we had some issues down there because no one was aware, or until I became involved in the easement, some real life examples that happened. We had probably, 60 yards of loam piled up on the easement, and that was a violation because it wasn't loam that was there prior. So she simply said, can you move it now or soon, and can you just get rid of it? We were able to do that, and we were more than accommodating. Another real life example was a real abutter, because I don't believe the society is an actual abutter if the county owns the land. There was an actual abutter who was dumping his leaves and sticks and stuff onto the county property, which was in the conservation easement. And in working with the society and with the land steward, we were able to talk to the neighbor about what they should not be doing, and that was rectified. But that was working with a relationship with the land steward. A big one we had was the city of Dover was putting a pipe in from a landfill across the river on the other side of the Cocheco, and it came across a walking bridge across the Cocheco onto the county land. And we met with the city of Dover prior, along with the land steward, and found the best way to get away from the conservation easement. And this was an underground pipe. So we were able to work with the society and reroute the pipe so it's not on the easement property. They're there to help you. They're there if you have a great relationship. They're not that type of a society that comes in and this is what you got to do. And I can't say enough good things about the society.
Can I add?
Sure.
Go ahead.
Can you tell us if Stratford County came to regret doing this easement on?
No, again, it's the
Majority
pre-planning. No one thought, county government would change in 10, 15 years. And down there, this is a big parcel
Right.
for Stratford, because Stratford's blowing out as far as residential homes. And I wish we really would have sat down and examined what county government may be like in 25, 30 years from now. But that was a small parcel too. That was only 300 acres. This is
Sure.
anywhere between 8 to 9, whoever you talk to.
Well, Ken, you've shared this. Of all of us sitting here, you're the one who's, I lived with this.
Mhm.
What would be some of your thoughts or suggestions that this committee do, or the county do, if the decision is made to go forward with this? What would be some, I'm not gonna say flags, but what would be some of the things you say, okay, but be aware of this and look at this and so forth, based on your experience, that you mentioned that pre-planning is very important on this. Where might we be 10, 15, 20 years
Yeah.
from now? What might be some of the demands on county government? So again, what would you say, okay, but take a look at this perspective, approach it this way. What would be some of your comments and I'm not gonna say concerns, but just some of the things that you would want to alert us to.
I would look at more at this 50 acres that this complex is currently on.
Yeah.
Some point, this building's got to be built because it's already 45 years old. We've already outgrown this. There's not enough office space for what we've done in the last 10 years. You know, the county government's continuing to grow. And with the way managed care is coming about, I don't know how that's going to look. If the county might have a big impact on us for that, you know, we may take that over. I don't know.
Yeah.
But there's enough land here, and I don't think the society wants all 900 acres. I think 500, like Mark said, is a good number. That leaves us with between 300 to 400 acres to,
Yeah.
you know, to kind of look at expansion-wise. But sitting here, I think we should get, we should have more listening sessions, what people think should happen. We should look at the demographics of the next 15, 20 years. I know the state has put together a demographics team to look at the demographics coming up in the next 20 years. You know, assisted living facilities, I don't know.
Yeah. What we do know is, based on trends, the county's getting older. I believe that we have the highest, oldest,
Or one of, yeah.
medium age of any county in the state. And so that trend, you know, is probably going to continue. And so I think some of your points here about assisted living, nursing home needs and so forth is certainly very relevant. And while we can never predict what's going to happen, we can take a look at those trends
Right.
and say, okay, this may be a need that we can't ignore.
And particularly since an easement is forever.
Yeah.
And looking down just 20 years, we all know how fast our lifetime has
Yeah.
gone before the.
I've got another question. I want to pick up on where Sandy was going with the trails. And you had, if I understood you correctly, Tom, you said that, you know, there wouldn't be a problem there. But I also got a sense that if all of a sudden we decided to connect two trails, you would have to go 200 feet into the woods or something like that, or maybe widen one trail, they would have to come to you and say, we don't have to come to you at all.
It doesn't have to come to us.
Okay.
If you had a question because of maybe it going through some sensitive area or something, we'd really hope you'd contact us ahead of time. Because what we don't want to have happen, if possible, is have you go ahead and build a trail, and then we come out on our annual visit and discover a really serious problem because you did blow through the deer yard, or you did fill to cross the wetland in some inappropriate way. We don't want to have to pick up pieces and resolve something after the fact, because it's way harder to do that than to talk proactively ahead of time if there's a question about something. But a trail is an example of a so-called by right use. It's a stated exception that as long as what you're doing is not going to be detrimental to the other purposes of the easement and the other special conservation features that have been identified in the easement and in the so-called baseline documentation report that accompanies the conservation easement, then you can, with some confidence, go ahead and build that trail connector and not be worried that we're going to later have a problem with it. Again, I think you're going to likely use common sense and know if you're dealing with a site that's maybe questionable, and in which case call us, and we'll come visit, we'll come help you evaluate the site and see if there might be some alternatives, and just try to help think through.
Getting back to what Ken was saying about pre-planning, this committee has looked at many uses of the property. A lot of it would, in the beginning, be non-commercial. But the potential for it turning into commercial use is there. Is that something that we could write into the easement? An example would be an equine trail that you know, in the future, maybe somebody would want to rent a piece of our property and build an equine shelter, and then have those people come and pay money and use the trail.
Mhm.
Things of that nature, can that be written into the easement?
Well, it's written in effect, in that second reserved right that I described, for commercial activities that are not agriculture, that are not forestry, that would be allowed as long as they have a minimal impact on the conservation resources. So if you have an existing set of trails that are being used for non-commercial outdoor recreational use, whether that's snowmobiles, cross-country skiing, ATVs, I mean, you know, that's your prerogative. But if you want to convert or make commercial use of some of those facilities, and you might be talking about someone coming in and building a for-profit equine facility of some kind, then the proposal to build that facility and or start charging people for the use of that network of trails, that's the commercial activity that we would say you ought to come in and propose to us what's anticipated under that reserve
Well, I
right.
would anticipate we would have excluded some property, and we would have that built on the excluded property.
Okay.
Any of those big, obvious use changes.
I guess
But
what-
then going out and using the trails.
But you're not charging people to use the trails, you're charging them to board the horses.
That's correct.
Well, that's true.
So
Very
then-
good
so-
point,
Yeah,
good point.
So there
exactly
is.
right. And we've often suggested that. As long as you're not physically charging people to use the trails themselves,
Right.
but you're charging people for the parking and the facility where it's kind of the trailhead that may be out of the easement, that's your business. The other thing to think about and just be aware of is that when you start charging for people to use outdoor facilities or trails or your lands, you lose the protection of the state statute that otherwise exempts from liability landowners who permit the public to use and enjoy their lands for outdoor recreation as long as the landowner is not charging for that use. So it's not that you can't do that, it's just you need to be heads up if you are going to start
So you have
charging
to
for that
make
kind of thing, that you may be losing out on some exemptions that otherwise you enjoy under state statute, under multiple statutes.
But that doesn't negate leasing out land for them to build a barn. We just can't charge them to use the trails.
Exactly.
You may be able to charge to use the trails. All I'm saying is we would want you to be applying to us for the ability to do that. If you're adding a new commercial component to the use of the conservation easement land that's not clearly agriculture or forestry, then to undertake that new activity, we're not saying you can't do it, we're just saying we want you to make a proposal to us, help us understand what you're proposing to do, and we're going to ask pretty predictable questions about, all right, where are people coming from, where are they parking, how much intensity of use, frequency of use, this, that, and the other thing. And then we will make some assessment of the impact of that new commercial component and decide whether we'll approve it or not. So it's not a matter of yay or nay. It's not that the easement says you can or can't do it. It says there's a process by which we expect you to come to us with a proposal that we'll evaluate thoughtfully with you and see if we can work out something that works for you but stays within the confines of protecting the land base itself.
And we can't even post the land under easement. It has to remain open to the public.
Actually, not.
Oh, really?
Yep, public access, I'm glad you mentioned it. A conservation easement does not automatically mean that the public must have a guaranteed right of use and access to the property. However, a couple of things play in the other direction that will promote there being some kind of guaranteed public access. Number one, you are who you are as the county. You are a public entity. And so not to put some sort of assurance in there may raise some questions in the eyes of maybe your own decision makers as well as residents of the county about whether this is a smart thing to do, because you are there to be serving the county, the public interest.
Public land.
But that's peculiar to your ownership. Secondly, if we are buying a conservation easement from you, some of the public funding sources, such as LCHIP in particular, requires a conservation easement that they're helping to fund, requires that the conservation easement have a guaranteed right of pedestrian access to at least some part, and typically all of the property. There's sometimes room for excluding portions of a property if you know the public's use is going to violate important privacy right next to the nursing home. I'm pulling this out of my head to point out an example. Or if you've got active logging operations going or active forest agricultural operations going, you do have an exception, a standard exception for posting those parts of the property for whatever temporary period of time you're doing those things. Because the last thing anybody wants is, you know, the farmer to be planting corn and having the public tromping across those 3-inch seedlings. That's not good for anybody's interests. So you have some rights. You know, there may be some safety issues, other safety kinds of issues that come up on a temporary basis where it makes obvious sense for you to be able to post property simply to protect the public from, I don't know what, but things can happen that are of a temporary nature. So having said that, we welcome, of course, inclusion of a guaranteed public pedestrian right of access within the conservation easement terms. But I can say pretty clearly, just from the Forest Society standpoint, you know, that if you're putting a conservation easement on 500 or so acres of your property, there's going to be good and plenty of public benefit associated with just that action alone to at least satisfy the Forest Society's interests and concerns. Sometimes we get easements that are kind of on the margin of sufficient public benefit. And in those cases, you know, it's really small or it's location, whatever, you know, we might press more for inclusion of a trail easement, right-of-way type thing to basically boost the goodness of the conservation easement so that we can proceed with the project. This is not, I would say, this is not likely to be such a marginal, you know, issue of threshold because of the probably hundreds of acres you're talking about and, you know, the fact that you've got a lot of good and worthy features to your property already.
So you would say 500 to 700 acres would make this a big project?
Well, it's certainly a good size acreage-wise. Big can be translated, you know, I've been using the word big more in the context of fundraising and money raising that we might have to do to complete a project with you. You know, obviously, if we had to raise $500,000 to be buying an easement from you, that's a really big effort and undertaking on the part of any organization, as opposed to raising $75,000 to complete the purchase of an easement from you.
So this isn't something that, if we agreed to a new easement, this wouldn't happen tomorrow?
Absolutely not. For multiple reasons. One, the crafting of the conservation easement, I think, is going to take more time than typically we spend with a typical private landowner. Because you've got a lot, you're thinking about a whole lot of things appropriately, but you've also got a land base that is somewhat diverse, and you want to think through. I mean, as Ken is suggesting, you want to think through as hard as you can up front what areas should be in or out of the easement. Do you want to think about some zone approaches if you've got some sort of in-between areas that, could use some level of protection, but maybe not the full array of restrictions?
Tom, would you talk about the special exemption piece of it? That it's not a full conservation easement, but like in Stratford's case, there were little
Well,
pockets.
the best example, I mean, I referred to the scout camp, There's and this is also true with the other boys' camp that we hold an easement on, Camp Belknap. In Tuftonburg. Yeah. We have an easement on the whole property. Well, if you've been on the property, there's over 100 buildings on the property, and they can build an unlimited number of more buildings on that property. Granted, that's a little bit of an unusual easement for multiple reasons. But the point is, they can build a lot more buildings as long as the fundamental purpose of those buildings is for a nonprofit youth camping operation. So that's kind of the restriction. That's a lot more lenient than our standard easement provisions that say no buildings or structures except for ag and forestry and outdoor commercial or sort of conservation related purposes. So in that instance, we have a pretty lenient whole easement that would be perhaps an example of a zone where maybe I don't want to invent something that's inappropriate, but there may be an intermediate area where you welcome some restrictions. You don't want it wide open, but you do want more flexibilities there than maybe conceptually the outermost areas that are more remote, where you want a fuller array of the standard easement terms. All I'm saying is that kind of thing is possible. So it would take time. And the other thing that takes time, especially, is if there's a fundraising obligation on the easement holder's part. It's rare that we undertake a sizable campaign without typically a couple years. And the reason for the couple years is, LCHIP or some of these other grant sources, you apply, LCHIP for example, you apply in whatever it is, May or June. The decision to award monies, so you have to have your kind of act together at the time of application. The decision to make an award is late November, early December, and then the earliest you could close would be the following March or so, but typically it takes a lot longer than that because you've got to get other fundraising done. You typically try to do the public grant funding first and then raise your private funds as the last part of the campaign because that usually works the most effectively. So you want another summer or fall and year end to raise private monies. So you're pretty much talking into 2 years before you complete a sizable project, a sizable fundraising project between the public grants and the private fundraising. And just the work, if you have a lot of surveying to do, that has to get done as well. So these things take time.
Tom, okay, so in the whole scheme of things and the sequencing, the timeline, would the draft easement document, does that precede or succeed the fundraising?
Usually, in terms of sequencing, if there's going to be a purchased easement, then it's in our interest, and probably yours as well, to have a good appraisal done before we even get to the point of reaching agreement on a price.
No, I understand that, but I thought you said you had to have at least a draft conservation easement document to help
The appraiser.
the appraiser.
Correct.
So you would do that, then you get the appraiser, actually, the survey would come first, I assume.
No, the survey can actually be done quite a bit later in the process, because for purposes of getting an appraisal done, we can give a good map with lines drawn on the map and measurements of acreages that's in or out of the easement. We can give that to an appraiser, and that will be plenty sufficient for the appraiser's purpose.
Okay,
So the first kind of practical step is getting enough of a draft conservation easement deed in place, in writing, that for the most part seems workable, without necessarily going through all the T's crossing and I's dotting. That's good enough for purposes of the big ideas and the concepts about what's restricted and what are the reserved rights and so on. And where on the ground is the easement proposed to fall? In other words, a map.
so this is my question then.
That's the stuff that should happen front end.
And so then you get into get the appraisal, then you, at some point, it's a purchased easement, so you go out for fundraising.
Before we go out for fundraising, what we would need to do is sign either an option agreement or a purchase and sales agreement with you.
Fine.
Because the funders don't want to be giving big hunks of money and commitments of hunks of money unless they know there's a tentative agreement in place between the parties.
And does that potential funder
Yep.
review your draft conservation agreement?
I'm sorry, does what?
Does the potential funder
Yes,
review the draft conservation agreement?
absolutely.
And so now we've got a purchase and sales or an option between the
Yep.
conservation holder
Mhm.
and the county, let's say. Now we go out for the fundraising, and somebody who's going to fund it, what impact do they have on the actual final conservation agreement?
Great question. They have considerable sway and influence over
Mhm.
the final wording. However, they also recognize that there has to be some room to wiggle, because we can't know at the front end when we're signing a contract with a landowner, we can't know who all the funders are going to be and what their requirements are. And we structure the verbiage of the purchase and sales agreement to say something to the effect that the landowner and the easement holder agree and acknowledge that they will work in good faith to produce a final conservation easement that is in substantially the same form and content as the one attached, but that does not have to hold to it precisely. And furthermore, there's a sentence or two in there that says and acknowledges that certain funders will have certain requirements that have to be put into the easement, so that everybody's kind of on notice that there may well need to be some room for change and revision in the document.
But what happens then if one of the major funders has provisions that the landowner just will not
Yeah.
agree with?
That's my question.
So we know in advance what the requirements are of LCHIP and some of these other major typical funders. We know what they expect to be in the conservation easement.
Mhm.
And part of our job, part of any easement holder's job, if they're doing their jobs well, is to be clear to you up front, as well as ourselves, what those potential issues might be, so that we can anticipate and build into our agreement and discussion and the first draft, some kind of provision that for the most part is likely to meet LCHIP's demands and requirements. We've worked with LCHIP enough to know and be pretty good at predicting what they need. And they publish, their requirements. So it's not an unknown. It's very rare that something arises way late in the game, in the process, that somehow completely upends turns over the apple cart. It's
Okay.
very rare.
Another question for you.
Yeah.
Has the Forest Society ever had occasion to sell their easement holding to another conservation group?
Not that I know of, because there are not other groups just lining up.
Well, I was
Wait.
just curious.
Yeah. No, it's an absolutely fair question. We have assigned some conservation easements and actual ownership of lands to other conservation entities
With the landowner, the original
on
land
occasion. I'm sorry.
permission? If I'm
Uh,
the landowner and you've got the conservation easement and you're gonna assign my easement to somebody else?
We've done that in maybe no more than 5 cases probably in our history. Sometimes there can be situations where it makes good sense for us not to be the holder of an easement any longer. One of the instances where we've done this is sometimes we can act more quickly in an urgent situation where the best end holder of the easement is unable to do the project,
Yeah.
but we perhaps can step in and temporarily hold the easement. And then after the dust is settled and whatever the problem was for the better group down the road has resolved, then we can make a transfer to get it to where everybody understood and intended up front for it to go. But there may also be situations where we might hold a conservation easement, maybe it got given to us 30 years ago. It's out isolated in the countryside. There's nothing else around it that we have an interest in. And some other group goes and protects almost all the land around the one that we hold.
Yeah.
Well, from a stewardship standpoint, it's a little bit inefficient for us to be going out and checking our 25-acre easement every year when there's another perfectly capable group, maybe more local, that's going out and monitoring its 175 acres right next door. And that might be good reason for us to consolidate our interests and us to convey the easement over to the other group, because it's a better stewardship result.
Yeah.
And that can happen and come up.
Does that affect the limitations or the restrictions on the landowner?
No, everything stays the same. I mean, the
Okay.
easement is still the easement.
I want to pick up on that, though. Again, using Sandy's trail network here that we've discussed about expanding the trail, adding on the trail.
Yeah.
And say over a 5-year period, the landowner has established a real good working relationship with the holder.
Mhm.
And they're expanding their trail network and everything and touching base. But then the holder assigns that conservation easement to somebody else.
Mhm.
Number one, they do not have that working relationship with the landowner. They don't have that history and so forth. So they all of a sudden, Sandy calls and says, well, here we go again. We want to expand the trail network a little bit. But the new holder has a different view and perspective on that altogether.
Mhm.
And they say, well, no, we think we want to come out and really review this much more thoroughly than the previous holder had done, because we may have some limitations and restrictions. So that relationship of what had been acceptable and ongoing now all of a sudden faces a real major inquiry. Has that happened before?
No.
Okay.
And the thing to keep in mind is
Yep.
this is a really rare thing for us to be assigning easements that we
Okay.
hold. It
Okay.
has happened,
Yep.
but I'm guessing not more than 5 or 10 times out of the 800 or so of these things. So please keep in context that this is a really unusual thing
Okay.
to occur. And usually there's a pretty darn good commonsensical reason why we're doing what we're doing.
Okay.
It's not because we just think the landowner's a jerk or, there's going to be some good cause for us doing what we're doing. And we're not in the business of surprising anybody. We would obviously talk with the landowner ahead of time to say, this is what we want to do. We would make effort to introduce a new organization to the landowner. It's in our interest to facilitate a smooth transition if that were to occur, but it's pretty unlikely. The second part of the answer is, the easement says and should spell out what the expectations are about whether approval of a new trail is something that is required or not in terms of the process. And our easements are clear. And most of the time, for construction of a trail, the landowner does not have to seek our approval, nor do we want to have to give it, because it's such a routine, non-exciting thing. So there's going to be some degree of obligation on a new group to frankly follow the rules of what the easement says, not what they might prefer in terms of process. So yeah, there's some room for interpretation and being more involved or not than maybe another group was. But the process should be clear enough in the easement to be clear what's expected. And that's the landowner's entitled to that.
Tom, this is certainly not likely to happen, but if the society no longer existed, what happens to all the easements that you folks hold? You have to come up with some alternative easement holder to take on those obligations, correct?
Yep. There are two approaches to that. One is that some landowners choose to name a second backup group to hold what is called an executory interest in the conservation easement for that kind of possibility, albeit not a very likely one, but it's possible. And some landowners feel more comfortable and confident by having a second group involved. Now, frankly, you also have to find a willing group to take that secondary backup role, because it means, staff time and effort and so on to be involved in the setting up. We don't often assume that backup role in many easements any longer. We used to be very happy to do that. And we hold 125 of these executory interests ourselves. But they take a lot of work, and we're, in the grand scheme of priorities, it's not a high priority for us to be assuming backup interests in easements. So that's one level of protection that can be built in if you wish. But bottom line, there are actually two other levels of protection. One is that our charter, our articles of incorporation, require that in the case of dissolution, our so-called assets, it's questionable whether a conservation easement is considered an asset as opposed to a liability. When you think hard about what it really means, it's a burden. But we have an obligation to pass our real estate interests on to some other similar organization. Now, if we dissolve in a complete disarray, which some nonprofits occasionally do, we may not attend to that. The ultimate backstop that is there is the Charitable Trust Division of the New Hampshire Attorney General's office. That office and the Attorney General views conservation easements as a charitable trust in which they have an interest. And their ears prick up substantially when they hear about an occasional dissolution of an easement holder, because they want to and need to ensure that there has been an orderly transfer of that easement to some other responsible group. If the dissolving group doesn't attend to that, by default, the charitable trust unit of the state will in fact undertake the process of assigning the easement to some other group. It doesn't happen often, and it shouldn't happen, but it has happened in New Hampshire. And that's part of their duty, is to help ensure that this thing is still alive and that somebody's taking responsibility for it.
Makes sense.
But it's challenging for them, but that's part of their role.
Okay, to bring you back to reality and what's going on and the facts, what does it cost to have a 500 to 700 acre easement appraisal done?
I would suggest that you not think about a cost that would be less than, say, $5,000, something like that.
Or more than,
It could be considerably more than that.
well, because,
Depending on the complexity of the terms and also the property.
because none of this gets started without an appropriation. And that needs to, be addressed and the facts
Mhm.
looked at first with a solid number to take to the delegation.
Right.
And to the commissioners for that matter.
Yeah.
Because the commissioners, if it, 5,000 doesn't sound like a lot, but I just had a 75 acre piece appraised and it was $1,000.
Right.
So, right away that just talks like 10,000.
If you can agree with the land conservation partner to split the cost, then you can cut in half the exposure for yourself as well as the land trust.
Okay, now, the second one is, you represent the society. There are other conservation groups.
Absolutely.
How do we find the best fit for us?
The best way to do that, I suggest, is talk with the groups and meet with the candidates and find out, hear what they would describe, hear how they would answer many of the questions that you've peppered me with today. Hear what their take is on some of these issues. Ask them the hard questions about the what ifs. Have kind of the same interview process and engagement with others.
Should we have our own kind of outline of a plan in place to show them?
That's up to you. Part of any good land trust job is to help you craft a process that makes sense for you.
Well, see, you're the only expert we've seen. So what would be your suggestion as to the best fit conservation easement group for us, for the county?
Well, other groups you could choose to talk with. The Lakes Region Conservation Trust is a great group. I actually used to work for them eons ago, so I'm a little biased, but they do great work and they're excellent and capable people. You could talk with Don Berry, who's their executive director, and get a sense for their possible interest and involvement. Other groups, there are other groups that are spread a lot more thinly across the landscape, but the New England Forestry Foundation is one of them. They're kind of a New England-wide version of what the Forest Society is about. That's a rather crude simplification, but probably adequate for purposes of your understanding. So that could be a group that makes sense for you to interview or talk with, have a conversation with. What are some other, the Green Mountain Conservation Group? I don't know how much interest they would have in this, but you could ask. You're on their board,
Yeah.
right?
Certainly.
I think the first question to ask is what's the appetite of the commissioners and of the delegation to even move forward with this?
Right.
What if they don't want an easement?
Well, I think we ought to be able to give them some numbers and some facts to go with it. I don't want to just, as a commissioner, I don't want someone to come in and say, okay, well, do you think it's a good idea or not? I'd like some facts, some background, some options, some homework.
Yeah.
What I would like as a delegation member is just an idea of prices. I don't think at that meeting you would want to give a exact price. You just give a range of how much, because that's what anybody's going to ask.
Yeah, a range.
And also, at a commissioners meeting, you would want to know, I would think, who some of the potential conservation groups are, and which ones somebody would be recommending, which two would be recommending,
Well, I
and the
think
pros and
that's-
cons of each.
Unfortunately, I think we'd have to go out to bid.
I think
To
that
do
may
by
be
a
one of the
service.
things that we could, if this group comes up with some homework, some facts, and comes up with a couple of good suggestions, or possibly one, and we do some background investigation, and it may be the society, then we could go to the commissioners and say, okay, this is what we've done. This is our homework, this is the facts, this is our recommendation. And then the commissioners would be able to decide whether or not they were even wanted to talk about it, an easement, and then probably, I would expect, would take our recommendation. That would be my thing. We might want to go and ask them at the beginning if they are interested enough in having us do the research. Then I don't have a sense, do you?
I've only heard from Mark, and I don't know what the others even want. I mean, I don't know how the delegation's gonna feel,
Yeah.
I have
So
no
it's,
idea.
but I think,
That's why, I like to find out first what their feeling is. If they don't even wanna do this, then, but if they think it's a good idea, maybe that's when we start doing some of the research.
I think we can do some without getting too involved. For example, Peter, would Green Mountain Conservation Group be interested in purchasing an easement here?
I can't.
Put you right on the spot,
Yeah, I
didn't I
can't
do? I'm
speak for,
sorry.
I mean, we're a small organization, we hold about 9 easements. We've been involved with some farm and ranch land protection programs in the fundraising effort. Whether or not the group would, this would be taking on a sizable obligation, so I'm not sure that they would have the wherewithal and the energy to take on such a big project. But I can certainly feel the group out. We meet periodically and get some sense. I know in terms of discussion with the commissioners, I'm just guessing, and these are, and Tom can either agree or disagree or revise the figure, but I would guess a major survey of this size acreage is $10,000 to $20,000. I don't know, but surveying is a costly proposition. Organizations require stewardship funding, and Tom, what would the society expect as a stewardship grant to, to do the stewardship work?
If the easement were done tomorrow, we would look to put $15,000 into
15.
our combined endowment and legal defense funds. That's our standard amount.
And I did inquire with a very reputable appraiser, I won't mention his name, he's expensive. When I tried to get a figure out of him and he doesn't volunteer figures. But Tom mentioned 5, but an appraisal for this, depending on the complexity, it could be $5,000 to $20,000. And of course, you can shop around and find, but this was a very reputable appraiser, and he said it hinges on how complex it is and all the exclusions, because they're really doing 2 appraisals. They're appraising the whole property at fair market value, and then they're running around the state finding comparables that have listed restrictions on them that somewhat resemble this property, and they spend a tremendous amount of time, and so it's really 2 appraisals you're getting. But
With the size of this project, question for you, Joe, with this, and I don't know, I mean, to us, this seems like a sizable project, but maybe in the terms of other potential holders such as the society and so forth, this is where we do stuff like this every other day. But with the size of this project limit, some companies such as, Peter St. G, I'm not sure we have the resources to take on something this size, but would that be a limiting factor as well?
Probably the limiting factor is going to be the size of the fundraising effort and campaign.
Okay.
More so than the size of the property itself.
Okay, all right.
That's the hardest nut to crack on a project that involves serious buckaroos to buy a conservation easement. Doesn't matter whether the easement's 20 acres or 2,000 acres. If you've got to raise a pile of money to do a big project, financially big project, there are relatively few groups that have the ability and willingness to undertake that effort. So that's why
Maybe that's the list we should look at.
I would encourage you not to be having grand expectations that just because an easement is worth X dollars doesn't mean you can find a group willing to buy that easement from you for that amount of money. In fact, it's probably going to be a pretty significant reduction percentage-wise of that figure, because the reality is there are not a lot of groups out here that are just standing at your door ready to be shelling out big buckaroos to buy an easement.
My concern is there a way that when we're all done, we would be getting somewhere between, say, $50,000 and $100,000 for our easement. That would cover, because that's basically what it's going to end up costing at the beginning.
I would think the cost range for those three expenses would be between $30,000 and $50,000.
Yeah.
I don't know.
Well, that's what I came up with,
No
was
authority
50.
on any of that.
Well, I came up with 50 for the county.
Yeah.
And I would like to have some reassurance that the easement is going to at least bring that plus probably 10-20% more, because costs always seem to grow by 10-20% before we even started. And you're looking very vague.
Did I understand, Tom, we
Well,
talked about?
what's your question?
Yeah.
Are we going to be able to get over $50,000 for our easement?
I can't answer that. In terms of a price, I would think that if the Forest Society were asked whether we wanted to buy an easement on 500 of your acres, if the value of the easement is considerably more than $50,000, then I could well imagine that we could be willing to pay $50,000. But how much more is, we're dealing in abstracts here, because part of what's going to frame our willingness to do something is knowing what is the value of the easement. That's important to you and us. But also important to us is what do we think our prospects are for raising whatever the amount of money is that we're talking about within whatever time frame it is that you're looking to accomplish the project. We may have just embarked on some major fundraising effort for another project 2 towns away that involves a really big mass mailing to 5 towns in the area, including Ossipee. And so our ability to raise money on top of something that we might have just committed to is going to be probably a lot less than if this is the first new big project that anybody's done in this area. I mean, I'm just throwing out some circumstances that make each of those decisions unique, and I can't sort of sit here and answer.
Well,
very
because
readily.
those are the types of questions that the commissioners and the delegation, I think, are going to have.
Right, right.
We've got a ballpark of a $50,000 expense, and not saying that it would yay or nay people, but I think they deserve to be told, well, we'll cover this plus,
Plus.
you know, maybe we'll get twice this. Or the prospects of our getting our expenses back aren't very good.
We might,
That type of,
we might negotiate with you that we would take care of covering the cost of getting the survey done.
Or if the
So that
county
might not
gave you the land and you paid for all the, you know, for all the incidentals, I don't know.
Yeah, I mean, we've done that. I mean,
well, that's why I was asking you with the other conservation groups there are. You know, you work with all of them, right?
Right.
So you know the ones that might do those things. Now, it may be the forestry group is the best fit for us. But then in the back of your mind, you may be thinking, oh boy, you know, there's another one just down the road that might have all the things they need, that type of thing.
Depending on how much money's involved, the other groups that have the capacity to do financially large, complicated projects are really limited. I would suggest, you know, the Forest Society has the ability to do this. The Nature Conservancy has the ability to do this. And they, you know, for all I know, they might be interested in your lands, or they might not. They have a slightly different focus and interest than we do. We tend to be broader in the array of conservation features that we're trying to protect. They have a narrower focus on habitat-related and ecosystem-type protection. They still allow forestry in some cases on some of their easement lands, but whether that's a right fit for you, I don't know. But that might be another group that you would do well to talk to early on to learn more about your sort of range of choices. And, you know,
Is that the only other group that you know of?
no, I would say the Lakes Region Conservation Trust is another group that has the capacity to pull off a sizable project. I think those are the three groups that have the combination of both the local interest and presence in this area
Thank you.
and the capacity to do it. The New England Forestry Foundation might have the capacity, but they're spread really thinly across a huge area. And so their ability to bring to bear a lot of organizational effort to raise significant funds for one location, it's a bit limited.
And we're too far.
And that's not a criticism of them, it's just the function of where they are and how they operate across a much bigger area. They have one person who's covering all of New Hampshire and then some, so it's
And we're
very,
too far north for Moose Mountain Greenways, right?
I don't believe that Ossipee's part of their area. I could be wrong. They might be interested, I don't know. But you could ask.
What about Audubon Society?
They're really focused, they're not doing a lot of new acquisition work
Okay.
at present. You could talk with them and find out. They're really trying to stick to the basics of
Okay.
their core mission at present, and undertaking a big fundraising campaign or even a medium-sized one is, I would doubt something that they would be game to do, but you can ask.
Well, we've got 3 or 4 that should give us
Yeah.
a
Mrs. Comeau,
sense.
you had a comment, question?
Tom Howe deserves a bottle of rum or something. Because he's been talking now since 10 a.m.
Yes.
I really believe you should.
We've lost the quorum.
Yes.
And-
Eventually, everybody's going to leave the room. So.
I know.
And
Well,
I'll
if
still be
everybody's-
talking.
Everybody still
There
has
won't be
questions.
anybody else in the room. I'll just be
Everybody-
blabbering away.
Everybody still has questions, but Tempest Foods is here, and we've lost the quorum, and we can kind of close this then. Does anybody have any other questions or comments they'd like to make?
I would just like to thank Tom for coming and
Yes.
sharing with us twice now.
You're
This
welcome.
information.
Yes.
My pleasure.
And I want to thank you very much, Tom.
Good.
As always, you've educated us.
Great.
And again, I really appreciate you kind of focusing on this, and as Amanda says, you know, in a way, not putting words in her mouth, the next step is that, you know, just how do we proceed with this to see if there's any interest? I think that is a big question. Hopefully there will be to continue this discussion. But again, I want to thank you very much.
You're welcome. Thank
And
you.
I'll accept the motion to adjourn.
I so move.
Is there a second?
Second.
All those in favor?
Hi.